Okay, welcome everyone to this session. We would be recording this session and also live streaming it. So welcome once again to this session. This is obviously a very hot topic in it today. We would be from CCAOI, the Perspective and ISOC Delhi. We welcome you. The discussion topic is the new IT rules and also live streaming it. Sorry. Session and also live streaming. We were trying to see whether the live streaming is working or not. So the new IT rules, whether it is empowering control or controlled empowerment, and try to decipher what the new rules mean. The session outline for today is we'll have a brief introduction and the background on this paper. This would be followed by a fireside chat with Mr. Rakesh Maheshwari, who's already joined the call. He's the group coordinator and head of cyber law in Ministry of Electronics and IT. This would be followed by a roundtable discussion by speakers and participants on the rules. The speakers today are Aman Taneja, Indrajit Sarkar, Kazim Rizvi, NS Napinai, Prashant Sugathan, Torsha Sarkar, Anand B, Robin Wilton, Arundeep, Yashwardhan Azad, and a few housekeeping rules before we begin. The participants are requested to adhere to the code of conduct normally followed in such calls. We would request you to keep your microphone muted if not speaking. You may key in your comments or questions in the chat. We will take it up in the Q&A, or the speakers may respond to it in the chat. While typing in your questions, please tag it with a question. And if it is a comment, please tag it with a comment. In case you are making a comment or question, please mention your name and affiliation and be brief. So we have 2 hours with us today, but we have a lot to cover. So I'll just give you a brief on what this guidelines is all about. On 25th February, this particular information technology, the Intermediary Guidelines and Digital Media Ethics Code, Rules 2021 was released. It is applicable on intermediaries and social media, online streaming services like Netflix, digital news media, for example, those who publish news, etc., include online newspapers, news portals, news aggregators, but not e-papers. So the paper defines intermediary, it defines social media intermediaries. For interest, I'll just tell you what a social media intermediary is. These are intermediaries who enable interaction between 2 or more users and allows them to create, upload, share, disseminate, modify, or access information using these services. It introduces a term called significant social media intermediary. And they, for example, intermediaries who have more than 5 million users, the rules for them would be applicable in 3 months' time. These significant social media intermediaries need to have a physical office address in India, appoint 24/7 nodal officers to assist law enforcement agencies, appoint a grievance officer and a chief compliance officer. All of them have to be Indian residents. They need to publish monthly transparency reports of complaints received, action taken, content takedown, etc. Traceability of the first originator has been introduced in this rule. However, it mentions that there is no need to share message content or information related to originators and users. However, in case the message has originated overseas, the traceability of the first Indian originator can be demanded. It also recommends using automated tools to take down content, voluntary verification of users. While there are many other things, but I'll just request if you could mute yourself. Rahul, would you be able to mute people, please? So the paper also, rules also talk about extensively about grievance redressal and takedowns. such as acknowledgement of complaints within 24 hours, and to dispose of such complaints within a period of 15 days from the receipt of the complaint. They need to retain user data for seizing of services for 180 days and keep content takedown data also for 180 days. Similarly, for the OTT platforms, it defines online curated content, who a publisher is of online curated content. It also speaks about a three-tier complaint mechanism. The first layer with the streaming service provider itself, the next layer with a self-regulatory organization, which could be headed by a judge, a Supreme Court or High Court, or an eminent personality, and having 6 members. And the final level is with the government committee headed by officer from the Information and Broadcasting department. It also speaks of having a grievance redressal system, each of the tier having 15 days for addressing the grievance, or it moves to the next level. It also speaks about appointment of grievance redressal officer who has to be a resident in India, and the need to register with the self-regulatory organization, and which in turn has to be registered with the Ministry of Information and Broadcasting. It also speaks about age ratings depending on content, which should also be in broadcast when content is being streamed. And it also talks about all the decisions at the government level, for example, for deleting, censoring content, etc., should be subject to approval of the Ministry of Broadcasting, and the secretary has emergency blocking powers. Similarly, for the digital media, it also, the publishers need to comply with the code of the Press Council for Journalists, the program code under the Cable TV Networks Act. It also talks about establishing a 3-tier complaint redressal mechanism. First level at the publishers with a grievance officer in India to handle complaints. The next at a self-regulatory organizational level, and the organization should be similar to what is the self-regulatory organization for OTTs. And the next level is an intergovernmental oversight committee formed by the INB ministry and chaired by an INB official. And based on the committee's recommendations, the ministry can order blocking, deleting, or modifying contents. They also need to publish monthly complaint reports. So these are some of the, I've just touched on few of the points, but there are more, but I would now pass it on to Rahul, who has some questions to ask Mr. Maheshwari. So Rahul, over to you.
All right. Thank you, Amrita. Am I audible?
Yes, you are.
Okay. All right. Good evening, everyone. Thank you for joining us for the discussions on the new IT rules, which were long awaited because the groundwork for the rules had been laid for long, and then they were the draft rules were released in 2019. There was consultation done, but now the new rules which are released have not only focused on the compliance requirements for the intermediaries, but also defined what social media intermediaries are, and thereby laid down certain conditions that the organizations have to follow. Plus, it also touched upon things like code of ethics for the publishers, and it proposes a 3-tier architecture which includes self-regulation and also an oversight mechanism for handling grievances and the content-related matters. So to discuss this, we are glad to have amongst us Mr. Rakesh Maheshwari, who is the Senior Director and Group Coordinator for Cyber Laws and E-Security with the Ministry of Information Technology and IT. Welcome, Mr. Maheshwari, and thank you for agreeing to join the discussions. Can you please turn on your camera and mic so that we know that we are able to connect you?
Yeah, I am able to hear you.
Perfect, sir. So, sir, thank you for joining us. As you know that we have structured this discussion with the intent to understand what these rules are and how do we try and what do we make out of these rules, because since these rules have been released, there has been a lot of speculations, some confusion. Some media professionals described it as very complex. So like we wanted to hear from horse's mouth, like what are these rules, what to make out of it, your brief comments, and then we will discuss subsequent things in the questions. Over to you, sir.
Yeah. Yeah. So thank you, Rahul, and thank you, Amritaji. As you are aware, the IT Act does provide exemptions to intermediaries via its section 79, while simultaneously conveying that certain due diligence need to be followed by these intermediaries, which is primarily contained in 79 2C. That's where it is mentioned that due diligence need to be followed, and primarily for that reason, based on the last amendment in 2008, the rules were published. The intermediary due diligence rules were published in 2011. A lot of water has flowed since then. A lot of experience has been gained. In fact, there were few court cases. Particularly, I just like to mention one Supreme Court matter, Prajula case, which was a suo motu criminal case taken up by the Honorable Supreme Court, and as part of, which was relating to rape and gang rape videos, but later on also included the scope of child sexual abuse. And that's where the court observed that the government of India may frame necessary guidelines to eliminate child pornography, rape, and gang rape imageries. There were also issues of fake news, which particularly, and lynching, which happened somewhere, in June, July 2018, which forced a calling attention motion in the parliament in July 2018. There was an ad hoc committee from Rajya Sabha, which also dealt with the subject of obscenity. And then there is an ongoing case, which is a transfer case, filed by Facebook, wherein the Honorable Supreme Court had asked for the commitment from Government of India as to when the new intermediary rules, which were already in process, as you have rightly mentioned, since 2018 December, as to when they will be published. And therefore, the process, the whole thing was already overdue. In between, because of the emergence of new technologies and new services like OTT, particularly the VOD, video on demand platforms, streaming platforms, while the services were offered online and therefore were considered to be, covered with the Ministry of Electronics and IT, but the fact remains the content of those services was the one which in the offline world was being dealt by Ministry of Information and Broadcasting. And courtesy that reason, we had deliberation. And finally, on 9th of November 2020, that a separate allocation of business rules was carved out for Ministry of I&B. And because the activities were in the online world, that it was considered that why not have a combined rule for the digital media as also the intermediaries. And that's how the new intermediary rules and the Digital Media Ethics Code 2021 has come into existence on 25th of February 2021.
So thank you. That was that gave a comprehensive background to why we are where we are and what led to these rules. So it's very useful. So we wanted to understand from you. So how in the Information Technology Act, how do we understand intermediaries? Is intermediaries is you gain the status of intermediaries when you perform certain functions or when you don't perform certain functions. So like, for example, if you select the originator, or for example, if you modify content, if you exercise editorial control, then you don't remain an intermediary and you have to fulfill certain criterias, and then only you will be called an intermediaries. Now, in these rules, intermediary is being treated as a class of organization. Like it's based on functions, but for example, it's as equivalent as you are a data fiduciary or you are a data processor. So what like prompted change in thinking, because an organization can or cannot be an intermediary. So how do they have this permanent status of being an intermediary? How does that work out?
So once again, I mean, see, any digital service provider, the rules are applicable as far as intermediaries a part is concerned only for that particular function for which you are acting as an intermediary. So, for example, let's say, I mean, any platform, I mean, if we take, let's say, as an organization, I'm publishing my website. Now, this website is the one where the information is owned by me, controlled by me, but this website also provides a facility for user interaction. So for the purposes where you are the custodian of information, you are the publisher of information, you are definitely not an intermediary, or definitely you cannot take the advantage of being an intermediary. But for certain things which are in a way user generated or third party generated. So the definition of intermediary is in the context of the function and the extent of function that you perform, and the very I should say, by virtue of the fact that as a platform, as an intermediary, you may not be immediately able to control the contents that are being hosted on your platform or stored on your platform or are being transmitted from your platform, that the law almost across the jurisdictions provide certain immunity, and that's what is there in the IT Act. But also it's a fact that this immunity cannot be, I mean, even the fundamental rights are not absolute. So this immunity is also not absolute, and you have to follow certain due diligence, which is what, therefore, were there in 2011 rules and continue to be there in the 2021 rules. Of course, the context, the ecosystem, based on the context, the ecosystem, the evolution of technology, the speed with which things go viral, maybe the new context has come into place.
Right, sir. So I think that's helpful because that clarity on when these rules are applicable in the context of when the organizations are able to claim the safe harbor provisions under the intermediary rules. I think then only they become the intermediaries. So second question related to this is slightly different but connected. Is we have always discussed since 2011 rules came out, we have always discussed in various events, forums, and online and offline conversations about classifying intermediaries into various categories, because if we go by the definition of intermediary, everything is or potentially is an intermediary. So clubbing them into one single bucket or rule, it creates a lot of challenges on how do you have a single common framework that is applicable to all. So in these rules, were there deliberations on adding more class of intermediaries like B2B, B2C based on the functions like telecom or content provider, or because the rules only define specifically social media intermediaries and significant social media intermediaries. So what led to just being the rules being reduced to these two? I mean, we understand the challenges, the forefront.
So first of all, let's not think that these intermediary rules are only for social media. In fact, the first part of the rules, so which is in a way rule number 3, applies to all intermediaries, and your concern is valid that given the variety of intermediaries that we have, why should there be one shoe fit all kind of a rule? But that is how there are certain, I should say, generic characteristics of an intermediary, which is what has been covered in rule number 3. And given the fact that today the most, I should say, the influential category of content hosting platform happens to be the social media platforms. Therefore, in a specific, that the other, I mean, the rule number 4 deals with the significant social media platforms, but it does not prohibit the ministry or the government to come up with additional due diligence rules as applicable to different classes of intermediaries. So it's quite possible, for example, tomorrow, maybe we can come up with an intermediary rule for ISPs, an intermediary rule for cloud service providers, an intermediary rules for CDN, and intermediary rules for maybe wallets. So depending upon the nature, maybe e-commerce websites. So it's always possible. The act permits publishing of such intermediary, I should say, due diligence for different classes of intermediaries.
Right, sir. And I think, as we, get into more nuances of this space, as more and more technological services are made available to users. So we are also seeing, the adoption of technology and regulations which are specific to technologies. For example, now we have like a blockchain strategy or a drone related policy. So we are slowly venturing into this space where, since the short domain by itself are getting very vast, so they will need specific rules or specific guidelines that particularly confine to the space that they operate in. So I think we surely expect also that we'll have more rules, but I don't know what the timeline is for when they will be out. But yeah, we expect. So a related question to this is that the definition of social media intermediaries based on the function that it provides to user to interact, converse, share details, that does not exactly distinguish between B2C, the services which are for the masses public, and B2B. Is that by design, or or the rules intended to cover all social media intermediaries, whether they are B2B or B2C? So because the business users also have specifically flagged these concerns, so I thought I'll just raise this up and get your views on this. So we are not able to hear you.
So your question is very well. I mean, your concern is quite well understood. I mean, is understandable. I mean, in the context of social media, if you look at, ideally, we have actually mentioned, I mean, where the main function or the significant function is actually enabling interaction. Right. So when we are saying like that, I mean, ideally, a B2B sort of conversation and many other activities which can enable user interaction, but that's not the key function of that particular platform, should ideally be out of the social media definition. So they are supposed to be out, but parallelly, please also understand that we already have the Personal Data Protection Bill, which is in the Parliament under consideration by JPC. That is where also the definition of social media has gone into the act, I mean, the bill which is presently there. So depending upon what shape the social media definition, I mean, social media intermediary or social media platform, or whichever way, I mean, it comes up, maybe this bit of definition may undergo a slight clarification in time to come.
All right, sir. That's very helpful, because I think a lot of business people have sort of talked about it. So I think good to hear that.
It's definitely not business or something where the business transactions or some other focus is there of the platform. So ideally, those entities should not be treated, and hopefully will not be treated. I mean, in time to come, if the clarification is maybe asked for, and hopefully we also become wiser. I mean, most likely in a month or two, as the PDP bill goes through the Parliament.
Okay, perfect, sir. Then, sir, I have a question related specifically to the aspect of requiring messaging platforms to enable traceability to identify the originator.
Not the traceability, the originator.
Originator, yes, to identify the originator, and now specifically the Indian originator who has done it in India.
Indian originator, yes.
Yes. So the one related question, which I think you have grappled, through the course of 2-3 years while discussing this aspect, is how does it impact or does it impact end-to-end encryption? Does requiring the originator warrant that end-to-end encryption has to be broken done away with? And second is, because we have new companies which are coming in, a lot of startups who are getting into this space, developing products, building services, and they also have aspirations to become significant players. So like they will aspire to become significant data social media intermediaries, on significant data fiduciaries for that matter. So is it requiring like a technology paradigm shift, that if the companies are looking to build these software and products, so they will have to factor this rules and requirements, that you will need to enable features which requires you to identify the originator of the message? Your brief thoughts on this.
So, Rahulji, first of all, in my own opinion, as an engineer, I will like to convey that identifying the originator of a message does not in any way dilute the encryption or the encryption technologies that any platform is using. Okay. The very purpose, for example, PKI, for example, if I take, so a document, when it reaches at the other end, what is really matched is the hash. So as long as the hash remains the same, the integrity of the document, integrity of the message can be maintained. And along with the hash, if you add so each time, if the message continues to be electronically identical, the hash will continue to be the same. And if the message changes by whatever amount, howsoever small the change may be, the hash will immediately change. That means the message has actually changed. So the whole idea is, as long as it is the same message which continues to flow, the problem is basically in the social media is that of the virality and the associated problems that it can create. Now, in such a scenario, on one side, when we say that the platform should not allow the users, or in its terms and conditions should convey that A, B, C, D, E, X are not allowed. And on the other side, platform, just by saying that I am an end-to-end encrypted platform, therefore I do not know as to who has uploaded, is actually contradicting their own statement of intent when they are putting the terms and conditions. So that's point number one, from a legal perspective. From a technology perspective, I did mention that any message which goes on the internet, you can always generate a hash which is a very small, I should say, value in terms of the storage size. The hash continues to be the same as long as message continues to be the same. I'm not saying therefore restore the hash. Say for example, many messaging platforms claim that they are not storing the contents. And we are not really asking the content to be stored by them. We are only asking store the first hash as and when created. Maybe continue to drop the hashes if the same message is floating around. So in a way, you will get to know if a message is becoming viral or not, which message is becoming viral in which area, but simultaneously you continue to be unaware of the content of the message. So we have categorically conveyed that this message itself has to be presented when the request is made. So message has been, because in the end user devices, the message is already in the form of, it is already decrypted. So message is already available in plain text at the hands of the user, which is what, if and when become available to the law enforcement agency, who simultaneously feel that this message has created or has the potential to create either issues relating to the national security or maybe issues relating to the child sexual abuse and heinous crimes, then only invoking the provisions of section 69, which is a very, very limited and very, I should say, hard procedure to invoke, or through the court order. So one, I will say technologically, it should be possible to really I should say, detect the first person who has initiated the message without ever knowing the content of the message. Two, because of the privacy reasons, the way the whole rule or the whole sub rule will operate has been made intentionally very, very hard, so that the provisions of, I should say, the identifying the originator are not misused. And because if your mobile number, or because that's how, I mean, it will normally be associated with, if this happens to be of Indian, I mean, if it happens to be of the Indian number, so the first person who is sending from within India becomes, in a way, the originator for us in the Indian context, which is what we are asking. And all these two things which I have mentioned, are technically possible and legally required.
All right, sir.
Rahul, I'll just take 2-3 questions have come up. Would you want me to share
Yeah,
them?
please. Please. Yes.
So there is a question from Arundeep. I'm just telling all the questions together so that Mr. Maheshwari can club as he wants. How far along are discussions for intermediary guidelines for other intermediaries that you mentioned as examples? This is from Arun. There is another question from Lisa which says, Instagram is the easiest micro-blogging platform that also enables small businesses. Who would be held liable if the company turns out to be a fraud one? Napinai has asked, the 3-month window for compliance in part 2, that is for intermediaries, is only set out for significant social media intermediaries. What's the timeline that the ministry is giving intermediaries to comply with the new guidelines?
So the answer is contained in the rules itself. I mean, I'm starting with the third one, because that's the easiest one to remember. So the rules have come. In fact, the whole rule has come into effect immediately, except for the significant social media platforms, intermediaries, for which a 3-month window has been given, primarily because, one, the technological aspect of the first originator in some particular platforms, and otherwise in all other significant social media platforms, because you need to appoint certain, I should say, designated functions who need to be resident in India. So primarily for such practical reasons, that time window of 3 months have been given. In the other OTT part also, the way it will operate, I hope, I mean, they have, because I may not be knowing the exact language as has been set out for the OTT and the online news platforms, but practically they have been given a month, or a month from their establishment, whatever is the scenario, to be able to, for example, the self-regulating bodies to be able to register. But simultaneously, it has been conveyed that it, in any case, I mean, if it takes a bit more than that, does not, in any case, stops their operations. So that's part number one. Now, coming to the responsibility as to who will be liable, will it be the user or will it be the platform? If I have understood the question right. So ideally, a user is supposed to be following certain rules of the game, and so is the intermediary platform. Now, if the user violates, maybe at the request of the government, maybe at the order of the court, maybe at the request of the individual in certain cases, or maybe by the due diligence being done by the platform because of the violation of its own policies, that the account, maybe the specific information which has been hosted by the user may be disabled or removed, or if this user continues to be continuous or repeatedly commits the problem, or has a number of instances where it has violated the policy, the platform also has a right. But we have simultaneously conveyed that the platform should be removing as and when any such thing arises, particularly when the voluntary takedown happens, that the platform should be informing the user. It can be user, it can be business. And if it happens to be a business with some maybe copyright material, which is making the platform as well as the business in a way doing certain commercial activities, then those contents to be suitably labeled. So all those aspects have been covered when we are talking of the significant social media platform. I hope I have been able to answer.
Yes, thank you, sir. There are two more questions before we go in. One is from Namrata. She says, will intermediaries be required to track the entire chain of communication in order to trace the originator? For example,
no. Immediate answer is no.
Okay. Right. The other question is from Pulkit. End-to-end encryption is in at least all significant intermediaries applied in case of personal or private messages and not on feeds or walls that are available in public and therefore subject to virality, which is the cited problem. In this case, why couldn't there be an exception couched within the guidelines to increase the privacy of public to exclude those private communications?
No. So it's not a question of, there are two types of platforms, which maybe the way we have visualized is one where the content is being openly published, and the second where the content is end-to-end encrypted and therefore is consumed only by the recipients of that particular message. Now, so therefore, the whole issue where the content is publicly available, if the content is a raw content, then in any case it is visible and the actions are taken either, because it is unlawful being seen by the person concerned, the government's concerned, or by the platforms itself. But when it becomes an encrypted content where nobody is able to see, but when the problem is being faced, there is naturally a need to know, particularly when you have already got the access of the contents. So I hope I am able to convey it clearly that the context, maybe when the platform is open, there is no need for, invoking this particular, I should say, originator rule itself, because in such a scenario, the platform otherwise also should be knowing it, because normally when the same message continues to flow around, the way the platforms are architected, they will only be having the first message or the first, I should say, image or imagery. But whatever is the scenario, but in whichever scenario that we talk of, it is on the onus on the platform to be aware of the first originator. I hope I am able to answer, but then if not, please do ask the question again.
Thank you, sir. There is just one question before we move. Sorry, Rahul, as in this is an interesting one, where Shelja asks, what happens in a case when a private gaming room is created by users and the chats of which aren't available with the platform?
And are not available with anybody else also. It continues to remain encrypted, that's it. And not available to anybody. So,
in that case, the whole idea is,
the whole idea is, if the law enforcement agencies or if somebody who has been the recipient of the message puts a complaint, then only things become known. Otherwise, one-to-one, what I am doing, it remains a completely private affair.
So for that matter, related question is like, if there is a messaging service which allows you to post content, like messaging platform service, and the message disappears, like after self-destruct, let's say after a certain period of time. In that case, like it won't be required, to have the requirement of tracing the originator, right? Or is it, if your platforms allows message to
Rahulji, you just tell what should be the aim. The message, let's say, self-destructs, disappears.
Mm-hmm.
Does it make the crime less? Does it make it to be less? Does it automatically become less criminal or maybe less good, or whichever way we are talking? does it changes the attribute in the context of legality or illegality of the content?
So the content.
No.
No,
In my view, no. If the answer is no, ideally the capability should remain. So if you have captured the hash, the content goes. Doesn't matter. I'm not in any case, I'm not chasing the content. And when I'm chasing the content, I have already become aware of the content. So the question is only with respect to the originator concept will work as long as you are maintaining the hash, and hash has nothing to do with the content, but in a way it has got the content ID. And this is one way of thinking. I mean, I'm also not saying that this is the only way of thinking. Finally, it is for the platform to take the call, as I did mention again and again, I'm mentioning that the platform in its terms and condition is conveying that a user is allowed to do these things and not allowed to do these things. Now, if a user is doing something which is not allowed by the platform simply by saying that I am an encrypted platform, I cannot really know as to who is doing what, cannot be the excuse of not being able to do whatever is lawfully expected from them to be done.
Thank you, sir. Rahul, I think we could take a few points from these speakers. It may be good, sir. If you can stay for some more time, we would be very glad. The speakers need to make some points.
I'm there. I'm there.
Thank you so much.
Yeah.
So,
thank you.
May I request, I think Mr. Azad would have to leave early, but I would also, after Mr. Azad makes his intervention, I would be giving Mr. Azad 4 minutes to make his interventions from the law enforcement perspective. But for the other speakers, I would request you to make your initial 2-minute comment on this rules. Mr. Azad, over to you first. Mr. Azad, are you there?
Yes. Can you hear me now?
Yes, we can.
Yes.
All right.
If you could share your perspective, especially from the law enforcement on this bill.
Thanks a lot. Thanks a lot for inviting me to this discussion. And I think so far it has been very, very illuminating on various aspects of these IT rules. Wearing 2 hats, first from the Intelligence Bureau perspective where I was there, and secondly as the Central Information Commissioner, I feel, I have in mind a veritable huge debate on these IT guidelines. Now, as far as the requirement of the law enforcement agencies are concerned, there is no doubt about that. Obviously, in terms of whether it's the question of radicalization, there's the question of anti-drug, child sexual abusive messages, definitely for investigations, we have always required this kind of a help from the intermediaries. That's what I've got. My only issue is that Mr. Maheshwari said that it is very simple and the traceability of the originator should not be a problem. If that is true, it's excellent. I mean, there's no doubt, there is no debate at all about it. From what I have seen, whether it's Professor Kamakoti, who has given his solution to Madras High Court, or the traceability methods which have been suggested, whether through metadata, I don't think through metadata it is possible because you get everything except that, and through whether it's through the digital signature or what Mr. Maheshwari has said, the entire cryptographers or so far the experts have said no. Now, obviously, this is up to the intermediary now to say whether this is possible or not. Now, my fears are that if we push it very hard, either it should be first established that yes, without breaking the encryption, we are able to, get the originator. Then there is no problem at all. But however, if the intermediaries do express their reservations and say that this will certainly lead to a kind of a problem for us, then it's going to be a serious issue in terms of privacy. And mind you, because the data protection law has not been enacted, so once the individual privacy is out or leakages are there, who's going to pay for the damages? So I think we are here because the enforcement comes very soon, or you're giving only 3 months time to the bigger intermediaries. This is the crux of the issue. Now, I would love to believe Mr. Maheshwari when he says that it is absolutely possible. There is no problem. But I have a huge problem on the other side when everyone combined is saying that no, it will break the encryption. And once we break the encryption, it should be a free access to all. And today, the danger is, as Mr. Maheshwari would know, that even on WhatsApp and other platforms, lot of such messages are going, which also have implications for national security. Many a times, certain organizations make it very clear, as Mr. Maheshwari must be aware, that they don't allow internet to be used on their, mobiles and things like that. That's for privacy. There are certain security organizations, but in many loosely government departments, such messages are passed on. And if we have this vulnerability, then we'll have a problem. So my limited, point is that either if it can be done, nothing like it, because it will be great from the LEA point of view, but if it cannot be done and it breaks the encryption, it will be a havoc. Or thirdly, when the intermediary says, no, sir, it is not possible, what do we do? That is when we'll be presented with a dilemma. Thank you.
Thank you, Mr. Azad. We do have Anand and Robin here to speak on technical parts, but I will come to them. Before that, I'll go to Aman Taneja. Aman, your 2-minute point here.
Sure. Thanks a lot, Amrita, and thanks very much to Mr. Maheshwari for making the time and taking the pain to explain some of those provisions to us, which over the last week we as lawyers have been really trying to grapple with. I think, 2-minute point is that these are big changes. I actually have far lesser comments on the intermediary part of this conversation. I think the questions on traceability, there is a technical question there to be answered. And I'm actually really grateful for the clarification which came in terms of that the 3-month period applies to all of the obligations under Rule 4, because one reading that happened was that it only applies to Rule 1, which pertains to the appointment of the different officers, and not necessarily beyond that. And my one sort of worry with the rules in their current form, especially in terms of the compliance officer, is the personal liability that is being imposed on a compliance officer. I think it'll be it goes a little bit. So the IT Act itself, I think under Rule 85, Section 85 does say that responsible officers of a company can be held liable for violations of the Act, which this rule then maybe codifies into a process by which that happens. But the reading of how the rule is currently worded seems to suggest that a chief compliance officer becomes responsible for any and all illegal activities which take place on the platform if they're unable to take it down within the time period prescribed, within 36 hours. Then does that result in personal liability for a senior officer of a company, and is then liable beyond what is in the IT Act itself? I think that's
2 minutes.
That's a little concerning. So I'll pause with that and speak about the other bits later.
Right. Thank you so much. And apologies, I'm being rude, but I just have to look at the time. So next we have Kazim, and then we'll have Napinai.
Thank you, Amrita. I hope I'm audible.
Yes, you
are.
Yes,
Kazim, yes.
Yeah, awesome. So thank you so much, Amrita, Rahul, and ISOC for organizing this. And thank you so much, Mr. Maheshwari, for coming in and taking in questions and also responding to a lot of the clarification, which are so critical to sort of understand these new OTT rules. We're really grateful to have you today and speak to us about it. I think that's really sort of speaks volumes of the fact that the government is willing to listen and talk about these issues as we go forward. I have a few areas that I just sort of quickly run through. I think a lot has been discussed and will be discussed, but just a few points to start with. One is that broadly, I think it's welcome that we are looking to regulate big tech and the social media ecosystem, but I think at the same time we have to be very careful in terms of regulating it in a way which protects the freedom and privacy of user. And in the essence of a data protection law, I think it's important that we have narrow provisions to regulate the ecosystem. That's number one. Number two is on the threshold of the social media, the significant social media intermediary. I think that 5 million could be like a little smaller number. I think we could look at a higher degree of threshold, which will be important, especially for smaller startups operating out of India, and as well as other organizations which want to operate in India. I think they may find it difficult to have all the compliances in place. It could impact Atmanirbhar Bharat campaign as well. So I think the government could probably look into that threshold once again. The third point I want to sort of make out is that there's a need to have some consultation, at least on the digital media news side of the regulation, as well as on the whole traceability originator question as well. I do feel that maybe a technical committee could be set up by the government to look into these aspects and talk to the cybersecurity experts, the research community, to understand how to enforce the traceability, the originator requirement, which the government has proposed. The fourth point I want to sort of build on this, the fact that I think more than just the privacy aspect, there are security implications of originator of content. I think that's where the government might want to sort of relook into these aspects through a consultation, which I feel is necessary going forward. Having said that, I don't think anybody can deny that the state has clear legitimate interest and need to collect and process data to carry out the territorial sovereignty and security of the nation, but it has to be done in a way which protects the nation. I think a very simple example is the needle in a haystack. I think we have to sort of narrow the haystack rather than widen it. And last, just two more points. One is a couple of positive things. The appeal mechanism of content takedown is a welcome step forward. I think that's something which is very welcome, especially when we used to have takedown of content and there was no appeal mechanism. That's something which is welcome. And the last point I want to sort of make is that on proactive monitoring of content, I feel that a reactive approach would serve better, and maybe even though the government is saying that intermediaries shall endeavor to proactively monitor, I think that there could be some narrow provisions with regard to that. So that's my sort of early submission. Thank you so much.
Sure. Amrita, I'll take a minute here, because the most significant aspect of the rules, like we have not touched upon, and Mr. Maheshwari, I don't think he'll stay for the entire duration. So I just want to get his attention and his views. Like it does not concern him directly; it's a part of MIB, but just his views on the 3-tier regulatory architecture of self-regulation and oversight mechanism. Like who are clearly not meant to be under its ambit and who are, because we have seen that these rules are being invoked, and the MIB was very quick to issue out a clarification on who can invoke the provisions of this rule and who can order to collect some information accordingly. And so second related aspect, on Kazim raised in his last point on having the organizations, significant social media intermediaries shall endeavor to deploy technology-based measures and automated tools to identify certain content. Like one is government willing to develop some open source tools that it can provide to the users if they want to use it, or they will, for example, in various departments and ministries, for example, GSTN provides open source billing software and solutions for people who, as Kazim mentioned, MSMEs might not be able to deploy all the costly tools and solutions which are available. So is government considering that? That is one question. And second is, given the accuracies of these tools and solutions are not very exact, so would there also be a grievance mechanisms associated with it on how these content related to this gets classified and built? So, sir, if you can talk about both the aspects, that will be really useful.
Yeah. So should I speak?
Yes, sir. Please go ahead.
So first of all, once again, I'll go in the LIFO mode, last in, first out. I should say automated tools and other things. We have very categorically mentioned, first of all, that it should be an endeavor. So it's not that they have been made compulsory, but depending upon the size, the type of content the platform hosts, the kind of problems which the platform has, that the government is in a way putting a moral pressure on the platform and not on the users, on the platform to detect certain contents. We also appreciate whatever technology you may use, there cannot be 100% accuracy. In fact, in our 2018 version, if you have probably, if you still remember, maybe the scope of this particular automated tool was quite bigger, quite wide, and we were severely criticized, maybe because in a way the government was giving handle to the platforms to do the monitoring and surveillance on the contents. And precisely for that reason, and precisely for the reasons, as I mentioned about the Prajula's case, that the court was also very categorical that eliminate, in fact, the word was eliminate child pornography, rape and gang rape videos from the internet. So naturally a balance has been made. The platform have been morally bound to come out with an endeavor to do this, and everything, I mean, if you look at the proviso of this particular rule, that checks and balances, in fact, everywhere checks and balances have been made. So I hope that's take care of your last comment regarding the feasibility of maybe constituting a technical committee and it should be secured. I mean, it should be evaluated whether it's doable or not. See, everything is doable in the world. Maybe in your design you might not have worked out. Maybe in the new design it can be worked out, but please, I mean, if there are experts saying that it cannot be done, then there are experts also saying that it can be done. So it's not for government to decide whether it can be done or not. I am going by simple logic that the platform in its terms and condition is saying that XYZ content shall not be published. It is for the platform to work out a suitable mechanism of how to detect such content whenever they are being uploaded. Now the concern that in case it really breaks the encryption, it will never happen, because in case it really breaks the encryption, there is always the judiciary to take care. So either the government misuses or the platform misuses any provisions of the law or the rules. There will be check and balances, whether with the PDP bill as and when it becomes an act, or otherwise also with the judiciary being there and privacy being a fundamental right. I mean, there will be very little chances of misuse of any of the provisions of the law. Coming out with the possible misuse by, say, for example, law enforcement agencies, as you have stated. In fact, in the OTT and in the OTT case, particularly in the online news platform case, it has already been very categorically conveyed and clarified by MIB on the same day, almost on the same day, of course, by evening, late evening, that it is the MIB who is the ministry in charge for the contents with respect to the OTT VOD platforms and with respect to the online news and online current affair platforms. So that has also been very categorically conveyed. Now, we also believe, see, I mean, this you have mentioned the concern about the chief compliance officer being personally responsible, but then there also a proviso has been added. 1, 2, we are also, I mean, cognizant of the problems and the possible issues that it can create, particularly the timelines, the hard timelines that we have put in, 72 hours, which was not there. And there was a lot of, I should say, non-compliances being observed across the country. So it was precisely for those that the timelines have been added, and it is precisely to avoid the misuse that we also want, in fact, right from day one. I mean, my interaction with MHA, my interaction with law enforcement agencies had been that while the power is being given to you, the authority is being given to you, the accountability should also be there for the law enforcement agencies and for the appropriate government. And particularly, we have once again added one proviso that in case it's an unlawful information, it will be issued, the notification will be issued, the lawful request will be issued only by an agency of an appropriate government, duly notified. So checks and balances have been attempted to be made. Yes, I mean, you may be correct that maybe in some place we might have gone wrong, maybe we might have gone right, but maybe our intent has not probably been conveyed so well. We remain open to any such good idea. So it's not that the end, I mean, it's the end of it. 2011, there were rules. 2021, there were rules. There are rules. And if there is a genuine need, if there is a genuine requirement, as you had already mentioned at the beginning itself, that depending upon the platform category, platform nuances, technology, business, naturally, I mean, you can always have more rules. You can always have a provision to review even these existing rules if certain misuse of any of such provisions are found, or maybe the rules are found to be inadequate handling a particular situation. I hope I clarified.
Right. Thank you, sir. Thank you so much. Napini, next, you are there. 2 minutes, please.
I'll try and save you some time too on that if possible, because I've already shared a fair bit in terms of what my thoughts are on this guideline, especially with respect to part 3, which I believe are fair and square in violation of exactly what Mr. Rakesh Maheshwari had pointed out in the beginning, which is that intermediaries by their very nature can only be those who have no control over the content. And part 3, square and fair, deals with those persons who have control over their content. And therefore, it cannot form part of these guidelines. But I'd like to focus today's balance 1 minute or so on this matter, Prajwala, which has been mentioned a few times. As Mr. Maheshwari knows, I'm part of the matter as well as part of the government committee, which came out with some very, very, forward-thinking ideas. And all of these were done as a consensual process. That was the beauty about it, because there seems to be a lot of concern with respect to the usage of the word automated tools and the fear that it may therefore result in misuse, which is why I'd like to use my time to clarify on this. The part about developing automated tools for identifying content such as rape and gang rape videos or child sexual abuse content was something which is part of the consensus proposal by represented companies who are these content hosting platforms and search engines. Therefore, inclusion of this in the guidelines is not something new. It's already there as part of the proposals. The proposals were already accepted as part of the order in Prajwala, and the Supreme Court has already passed an order to the effect that they will develop these tools. Where the intermediary guidelines actually takes it forward is in ensuring that it will be a best effort endeavor for the social media intermediaries to deploy it also. And the part which I really appreciated as an addition in the guidelines was this portion which dealt with the exemption or the clarification given that despite deployment of these tools, intermediaries will not lose their safe harbor. That's actually an intrinsic addition which is mandated, considering that is a huge risk or a concern for every intermediary, because they come back to the issue of whether deploying such tools is going to land them without the safe harbor shield. So that's a very well nuanced provision and not something to worry about too much, because the first part is with regard to identifying a very specific kind of content and removing it. And the second part is with respect to issuance of notices pursuant to this. In fact, the rules stop short compared to some of the undertakings that are already part of the order in the Supreme Court decision. I mean, the October 2017 order, it also records that intermediaries will deploy spider technology to identify content which is already taken down or identified as child sexual abuse or rape or gang rape videos, to ensure that further uploads will not be done, and will also look backwards for similar uploads from elsewhere. One contention is always likely to arise on this particular point, and instead of talking about everything, I'd rather stick to just one point in today's intervention, and it is this point. We all, as people who are very concerned with free speech and expression, will immediately 100% raise this issue of the slippery slope. That a technology which is deployed for child sexual abuse, protection against that, or against rape and gang rape videos being uploaded online, could also be used to stifle free speech. that is something which is speculative, because today, where are we? We are at a stage where very precise guidelines are being set out based on consensual undertakings that have already been undertaken up to a part. Because the portion about deploying these kind of tools is not part of the consensus proposals. It's only right that I clarify that. That part is a non-consensus proposal, which has to be still decided by the Supreme Court. But in the meantime, if the guidelines are
Sorry, I need to...
in the meantime, if the guidelines are giving a best effort endeavor, that I still believe is a welcome move, considering the seriousness of the crimes that it intends to protect against.
Thanks. Just a small clarification. We do have different sections we'll go into. I think we are quite okay with time, but we need to stick to our 2 minutes. So Anand, over to you.
Okay, am I audible?
Yes, a bit loudly.
Okay. I will only touch upon one area, and I will throw some truth bombs into the traceability debate. The first and foremost technological understanding is that none of the E2E tools, as we stand today, use what is called PKI infrastructure. We have gone far beyond that. In fact, we have gone far beyond it for close to about 50 years. And what we actually use is what is called as Diffie-Hellman algorithms. I will not bore you about the technological bits, but this thing is not about PKI at all. So for instance, what we normally do is we generate keys, we generate encryption keys that change almost every message. And in fact, the Diffie-Hellman algorithm and the protocol that we use called X3DH is explicitly designed to ensure that even if you seize my device and you show that someone else has sent this message to me, it will not stand in the court. Okay, we call this perfect cryptographic.
The voice is distorted for me or everyone. Anand, your voice is getting distorted.
Is it better?
Yes.
Okay. Is it better?
Yeah.
Maybe
and
switch off the video.
Switch off the video, then
okay.
You utilize the bandwidth better.
Okay. So to put it very simply, we don't use public key cryptography at all in E2E. The entire protocol is designed on X3DH. And even if you produce a device, let us say you produce a device which says I sent a message to you, and that is proof that I sent a message to you, it won't stand in the court because the entire protocol is designed based on cryptographic deniability. It's a very strong cryptographic deniability. In fact, it goes much further. And what we actually do is, it is perfectly possible for me to forge an entire set of transcript between me and Rahul, for instance, which has never happened, right? We have tools for it, we have algorithms for it, we have scripts for it. This is really E2E, right? So in this, any scheme or any law which comes and tells about, you can insert originator information, you can insert hash values, you can insert anything else, is basically dead on arrival. And so that is a part we keep coming back to it again and again. You can always come back and say that, look, we are banning end-to-end encryption in India. I think that is a statement that the legal folks can make, and this is our do. I think we don't have a problem at a technological level. It is what it is, right? There are several other consequences that come out of it, but that is a different argument. But there is simply no technological means for anyone to make a claim who work on the cryptography side to say that we can add this extra bits and we're going to make, we cannot break E2E. That's basically where I want to stop.
Thank you, Anand. I'll bring in Robin now and then Prashant.
Thanks, Amrita. And thanks again for the invitation. It's a real privilege to be in this group. So I really appreciate Mr. Maheshwari's openness about these proposals. And I noted his statement that traceability doesn't dilute the encryption that is applied to content. And I think that really merits further examination and unpacking, because I think that's at the heart of some of this and some of the issues. So I think this partly relates to Anand's comment that we already know that hashing can be quite an unreliable mechanism. For example, as someone who's been involved with encryption and PKI since the mid-80s, I am one of the few people who still digitally signs their emails, which results in confusion by the recipient, especially when it goes via a mailing list, because what happens when a signed email goes through a mailing list is that it arrives at the recipient with a note that says, the signature here is invalid. So even a simple forward like that through a mailing list breaks the integrity of the digital signing because the hash has changed. And I think that also applies to image contents if they are sufficiently changed, the hash breaks and so on. So I think there are still some questions to answer there. But the point here is not really about encryption. It's about the binding or the association between a piece of objectionable content and an identifiable individual. I was really interested to hear Mr. Maheshwari say that because this is not about breaking the encryption, the rules only kick in when someone has seen and by implication reported a piece of objectionable content in clear. Well, that's okay, but let's not forget that in order for that piece of objectionable content to be reliably associated with an originator, you have to have something that cryptographically binds the two. So again, I think there are some questions still to explore about the scope of that binding and how it's achieved. If you're only hashing the identifier, you might be better off in privacy terms, but you lose the binding to the objectionable content. If you're hashing the whole thing, that hash has to be valid whether the content is encrypted or decrypted. And again, it's going to change. Otherwise, you lose the reliable binding. You need to be able to say, here's the encrypted content, here's the decrypted content. This is the decrypted content that was in that encrypted message, and this is the person it came from. And I think there are some real questions about whether hashing can provide you with a reliable binding there. If I can make one other quick comment, and this is about identifiability in general. I think one has to be very careful not to create some perverse incentives here that result in dangerous and unexpected outcomes. And one that I can see is, if, for example, I'm a terrorist and I want to stream a violent act, am I going to log in and do it with my own identity? Well, I might if I want the publicity, and especially if I don't think I'm going to come out the other end alive. I have nothing to lose. But I might also choose to go and threaten an innocent civilian until they give me access to their credentials, and then post my content using someone else's account. So I think there's a real risk here that we are creating a market for innocent credentials and therefore putting people at risk of threat from people who have nothing to lose. Thank you.
Thank you, Robin. Very valid points. Perhaps Rahul at a later date, and sir, if you have some time, we could have a special session on this part of the discussion on the traceability and other things. But I'll now move on to Prashant. Prashant, over to you. And then Indrajit, if you're...
Thanks, Amrita. Okay, I'll focus on 2 points mainly. One, see, most of these discussions center around major platforms like WhatsApp. But what happens in the case of smaller platforms, for example, Signal for that matter? There was a large exodus of people from WhatsApp to Signal when the new privacy policy was proposed by WhatsApp. And now they would also be considered to be a significant social media intermediary under the rules. But when you have requirements like having a, let's say, physical office in India, then persons resident in India, that's 3 level of officers who rest in India, for such organization, maybe, I mean, as far as Signal is concerned, their entire employee strength is less than 20 across the world. When you come with such restrictions, this could lead to maybe citizens of our country losing choice of various applications which they could use to protect their privacy, ensure that you have safe communications. And again, there could be a lot of open source tools, open source messaging platforms that could be used by people. The same happened with Twitter when there was like people moving to, let's say, instances of Mastodon. And what happens in maybe a federated architecture like that of Mastodon, I mean, like, or there are various other services which have a federated architecture. One instance maybe will have a less than this significant number, but if you add all these instances, the numbers could go up. What will be the liability of these platforms in those cases? There are a lot of areas which are unclear in such instances. Again, coming to automated filters. Yes, the language says that intermediary should endeavor, but then this could be a problem when you have wording like shall use there and then use word like shall try to endeavor. See, the problem here is when you have automated tools, a lot of content which could be validly legal content could be taken down. To give an example, there was this movie which had a recording of a film, sorry, a temple music in Kerala. The similar kind of music was recorded by persons, I mean, directly live from the temple festival premises. But then all these videos got taken down because the film music was copyrighted and had similar, or I wouldn't say identical, but similar content. Because this was the same music which was being played in that movie also. But user-generated content, which is validly taken, photographed by them, videographed by them, these were taken down. So when you mandate content which is taken down to be automatically removed by such tools, it could create a whole lot of issues. I mean, so these are the 2 points that I want to mention. I mean, a lot has already been spoken about traceability, so I don't want to get into those issues. But these were 2 areas that I wanted to highlight.
Thanks, Prashant. We'll have more from you. Torsha, over to you. Indrajit, are you there? I am not being able to locate you. In case you're not, then I'll ask Torsha to speak. Torsha, you go ahead, then I'll ask Indrajit.
All right. Thank you. I'll also restrict myself to really 2 issues, because one, I think most of the other issues other panelists and sir has already touched upon. And for me, it's the content takedown aspect of it, because it's something that I have been really interested in the past 1.5 years. And one of the things that really stuck out at the first instance was that the way the drafts treat intermediaries in a little more nuanced fashion than what it already was in the older draft. So, for example, in the 2018 draft, which the 2021 rules are an updated version of, that treated intermediaries as this monolithic entity based on the Section 2W IT Act definition of intermediaries. And while that might have been the reality of the internet when the IT Act was first brought about, it's been a very long time. That's not true today. And I really appreciate the fact that the rules take this into account and say we have intermediaries, but then we have social media intermediaries. And even within this class, there are certain companies who by account of user count or revenue generated amass a different sort of power and a different sort of leverage that we might need to consider different hierarchy of liabilities surrounding this. Thus, you have the significant social media intermediaries. So that nuance, because we have been working on the 2018 version ever since it came out, and have really been harping on the necessity of having more nuance into the content takedown system, and that goes at the very beginning with treating intermediaries as different entities based on their services and their user accounts. So that was one thing that I really wanted to flag. And the second is, I think there is also an effort to really give users more control over the way they interact with intermediaries in terms of complaints and the content. So for significant social media intermediaries, this includes that they are now mandated to give a user whose content has been disabled, they are mandated to give them a notice, they are mandated to allow them to appeal. There is also a possibility of users able to track their status of the complaints, and a lot of this actually lines up with international best practices on general social media platform transparency. So, for example, the notice and appeals mechanisms is very similar to the Santa Clara principles, which are a voluntary set of principles that the law has incorporated this. I think the factor about transparent reporting is also a great step towards the right direction, though I am concerned that it's a monthly periodic compliance report, like even in the next reporting mechanism, it's 6 monthly compliance period. So while I don't have enough data to say if there is an economic or onerous burden of putting out periodic compliance reports, that's a point that I really wanted to highlight. And last, I think just to add on to what Napina ma'am had already said about automated filtering tools being used for child sexual abuse imagery and non-consensual pornography. I think there has been enough research, like case studies that show that the corpus that exists to train this machine learning tool, it's much easier to create tools and solutions that can trace out this sort of imagery than opposed to something like extremist content or hate speech, which is much more contextual and subjective. And I think even all these big tech companies have come out multiple times saying that it's not possible at this stage, and like there has been other civil society endeavors that have pointed this out as well. So yeah, I think those are my three broad points there are. Thank you, sir, for
Thanks, Tosha. We'll have some questions for you, but now I'll go to Arun. Arun, you need to say, share your views, and especially since you come from the digital media section, so it would be interesting to hear your views.
Thank you, ma'am. So I will restrain myself to the OTT side of things more than the news, because this is something I have been personally looking at for the last 2-3 years. And it's worth mentioning that 2020 was probably the worst year for censorship of OTT platforms in India. We recorded 10 instances of OTT platforms either censoring themselves or responding to public pressure and making changes to their content. And the guidelines that came out with the 3-tier complaint redressal mechanism is not a new idea. It was something that the Internet and Mobile Association of India came up with in early 2020 as a 2-tier system. And this was rejected by a majority of streaming platforms who said it was too onerous. And they came up with a much more, they came up with a newer system that was also rejected by the Ministry of Information and Broadcasting. And now this kind of a complaint redressal mechanism for such a, for an industry like streaming services is kind of a disproportionate measure, in my opinion. It creates very bad incentives for, creative freedom. We have seen that with how small isolated bursts of outrage can, lead to, overt actions in terms of censorship. I think this 3-tier structure formalizes these objections into a legitimate way of suppressing speech. And there are precedents for such systems in spite of the many problematic things ultimately not being included. There are precedents for such systems to slide into questionability in terms of civil rights. For example, 3 years ago, some of you might remember this, there was a show called Pehdar Piya Ki, and that show essentially generated a lot of outrage because it depicted a minor kind of making advances at a young woman, and people, it was very rattling. It was very, it was not in good taste, to say the least. But the way that show was taken off air is interesting to note. The television is regulated by the Broadcast Content Complaints Committee, and that committee is also self-regulatory in nature. It is highly similar. In fact, it serves as the inspiration for the current system we have. The Minister of Information and Broadcasting wrote a letter to the BCCC and told it that this content is unacceptable, and the BCCC, which is supposed to be independent, acted upon it immediately. Now, the system that we have created here appears to be designed in a way that can lead to similar outcomes. And the rules that are there in the ethics code that say you have to exercise caution when you are dealing with sensitive matters like community, religion, and all that. Now, the place we are in as a country is a kind of getting to a place where the polity and the cultural aspects of society are kind of getting melded together in a way that making these little distinguishing between these aspects for regulation is going to be challenging, and it might pose serious threats to freedom. It might chill streaming services from making content that is politically provocative, which is not a desirable outcome when we have an art form that is emergent and fresh. It is always desirable that it push the envelope, it make it, push it, test the boundaries. And this system, as it is designed and as it precedents have turned out, is not does not show promise for creative freedom overall. And that being said, there have been some things that the guidelines have admirably kind of stayed away from, like requiring the censor board to come in, having pre-censorship, banning, having blanket bans on things like nudity and things that a lot of people were very concerned about. It has admirably stayed away from that, but now we will have to litigate individual objections to content at such a scale, and with such loose frameworks for what counts as legal or illegal content, and the broad wording of some laws that we have. Once this regulation kicks into effect, it will be very worrying, and interesting to see how it turns out. Thank you.
Thanks, Arun. Rahul, I'll pass it on to you. There were a few questions which came from YouTube as well as here. Or if Mr. Maheshwari would like, over to you for that part. And then you may have some questions for the panelists. After Mr. Maheshwari, you can ask them the question.
Sure. So, I checked with Mr. Maheshwari, but I think that he won't stay for the entire duration. So I just wanted to check if he's here. So I just wanted to have.
I'm there right now.
Yes, sir. Yes, sir. So we just want to have your remarks, given what we have heard so far. If there are specific things that you would want to address, and then I will take a few questions from the audience, that are specifically directed to you, and then we can proceed to the next part of the discussions.
I'd just like to comment on Mr. Arun's, I should say, observations.
Yes.
While I may not be competent on this particular part, I'll just like to mention that as far as the self-regulating bodies' roles and responsibilities and the authorities is concerned, they do not.
Hello?
The authority to ask.
Sir, I think we lost you for some time.
However, they can make a recommendation to the third committee, which is being headed by the Joint Secretary in MIB.
Right. Thank you. Rahul, there were a few questions directed to Mr. Maheshwari. If you can look at the document I have pasted.
Yes. So I'm just looking at that. So, sir, this question is from Mr. Rupin Sharma, who is DGP of Nagaland. And he has posted this question that, specifically on the requirements for the intermediaries to publish a report. So what will be the content of this report? Is there a template that is being specified, or will the report require the intermediaries to list down specifically to the the minutest detail possible, and what is the nature of the complainant, the content ignorance? So what can we expect from this report? Will these reports be made public? Some insights on that?
See, the whole purpose of having this report is to go public, one. Two, definitely the detail should be good enough to convey the kind of problems the platform has received and resolved, rather than going into each specific problem. So all those, I hope, as the time goes by, in any case, maturity in terms of what is acceptable as far as the reports are concerned will also follow. If required, an SOP will also come. But we have clearly mentioned that, in fact, some statistics of what numbers have been disabled will also be included in that. But beyond this, I'm not really expecting that maybe the specifics of the requests or maybe the resolution will be responded in these reports. So it's like any other report being published. As transparency report right now being published on a 6-monthly basis, but that's more to convey as to how many requests from government. This time we are saying as to convey as to how many requests from users. So the focus is changing, the frequency is changing.
All right, sir. And last question for you. It's by Dr. Govind, and that's addressing the elephant in the room. Is how to ensure that these rules will not be misused by the government to safeguards?
Yeah, so I did mention in the beginning itself,
yeah.
And somewhere in my answers, I did mention, yes, that while the authority is being, see, first of all, this authority was always available with the appropriate government as far as, because after the share single order, in fact, earlier it was also available to users. After share single, it was available to the appropriate government or its agencies. So it's nothing new as far as government is concerned, except for the time elements which have been added to it explicitly. 2, the scope has also been extended to cover now any unlawful activity as well. And that actually widens the scope and therefore the misuse potential as well. But simultaneously, we have also mentioned that any such agency who is giving a notice for anything unlawful will have to be notified by the appropriate government first. So in a way, it is a transparent process. And beyond this, I personally believe, and now this is not my response as a government, I should say, as a government officer. This is my personal belief, strong belief, that in order not to have misuse on either side, that only a limited number of touch points should be allowed to be interacting with any significant, or for that reason, any intermediary. So if you have, I mean, the country of this size, maybe say around 2000 touch points should be good enough, and though they can be whitelisted as well, so as to avoid the misuse, so as to create accountability into the appropriate government or into the law enforcement system. So those things are something which we have been and are working again with MHA and the appropriate governments, the various appropriate governments. But that is something to be seen. As I said, this is my personal view. Otherwise, not to be treated as the official view of the government.
Right, sir. And a related point on this is on the appropriate government. So different sections and different provisions of the rules talk about appropriate government. So for example, even with respect to requirement for retaining data, if it is required that data be retained for more than 180 days through a court order or through an order by any appropriate government. So does the meaning of appropriate government change with different provision? It could be a state government, it could be a regulatory body.
No. First of all, when the data is actually being retained. So normally, unless there is a contractual requirement or specified in that specific to the extent law which is being quoted by the appropriate government. So this is a generic requirement of 180 days, unless superseded by a contractual requirement or by a court order, or by the request of the appropriate government for a specific record, for a specific purpose. The reasons have to be given each time. So it's not a blanket kind of a requirement or authority which is being given to the appropriate government or to any law enforcement agency for that reason.
So there was a question from Prashant. He says that Rule 6 gives wide power to classify any intermediary as a significant social media intermediary. How do you ensure that such power is not used arbitrarily?
Once again, first of all, there are lots of provisions made in the rule. Normally they are not there, but then in this particular rule, in these particular rules, lots of provisions and therefore checks and balances have been made. For any notification to happen in Rule 6, once again, a material risk, the impact of that particular, function being provided by that particular organization as an intermediary has to be taken into account and accordingly notified. So beyond this, I can only assure you, and those of you who know me, those of you who have been interacting with me, and at the end of the day, it will be somewhere, if I continue to hold this particular position, I will be involved in the process. I can assure you it will not be misused.
So that sounds very reassuring.
Rahul, do you have some questions for the speakers?
Yeah.
No,
sure, but in case Mr. Maheshwari leaves, so I just want to thank him for not just staying for his part, but staying for nearly an hour and a half and interacting and taking questions to these dialogues help facilitate better understanding and also awareness on what is the intent behind these rules and what do we make of these rules and how these will be implemented, challenges. So, sir, thank you. Great, frank discussion, and hope that we have,
So, Rahulji, I mean, therefore, if you now permit me to leave this conversation, and I'll also like to thank all my fellow panelists, in fact, all the participants who maybe either interacted with me, I mean, by chats and through you, or maybe otherwise were patiently listening to me. Thanks a lot. Thanks a lot for giving me an opportunity to be able to convey and express our views, and also to be able to get a feedback of what the other side is thinking about it. And as I said in between, we remain open to, I mean, any good suggestion, something, I mean, because as I said, there is nothing called as perfect. We are all striving to do it better. And that's how it should be. And it should be taken in that spirit only. With that,
thank you so much, sir. Thank you so much for your time. And we'll definitely try to arrange something on the encryption part. Thank you. Rahul, you had some questions for the other panelists. We have about 25 minutes or 20 minutes. So.
Right. So, like, the format of the discussions which we had initially planned, it does not exist. But, what we'll try and do is, given that, we have time to discuss some of these aspects. So I will call upon Aman, and then followed by Prashant to, specifically discussed on two aspects of the intermediary guidelines. One is on the grievance redressal mechanism. And not just with respect to intermediaries, but also with respect to OTTs. Where do you think this does well, and what are the challenges in terms of, does it gives arbitrarily more power to platforms or the government to sort of play an active role in this? Your thoughts on this?
Sure. I'll actually focus more on the grievance redressal mechanism in part 3, which is on the OTT and news side, and I'll leave it to Prashant to talk about on the IL side perhaps. And I think I think Arun really made a valid point on this earlier when he was speaking about how this essentially you've sort of codified a mechanism for people to raise grievances and express outrage, and what happens from here on is what remains to be seen, right? Like that's, I think, really the proof of this will be in how it plays out. If you think about it, something like the CBFC is also supposed to be a certification body, but we know it as the censor board. So this is also self-certification, but does that then result in censorship and results in a number of edits having to be made, and people actually taking a more cautious line, given that now there is these 3 levels where there's direct oversight coming from the ministry, and those examples that Arun spoke about earlier. So that's definitely a concern that stems from these rules, and one which shouldn't be overlooked. I think, and apart from just the grievance redressal mechanism, I think that the fact that this entire set of obligations which now comes on digital news and OTT players coming through the route of rules rather than an act of parliament, I think is something which will certainly be questioned or should be questioned in times to come. I think it requires a degree of examination on whether something of this nature is possible to be done through delegated legislation. And to the point that perhaps Mr. Maheshwari also mentioned earlier, that I mean, if there is an abuse, then there is scope for judicial recourse. I would perhaps question that notion, because one thing which is conspicuous in its absence, perhaps in this entire scheme in part 2, in the grievance redressal mechanism, is that there is no clear line of appeal to any sort of judicial oversight on this. So the determinations are being made either by the entity itself, or thereafter, it goes to the self-regulatory body and then to the 3rd level review. But at what point is there any scope for judicial intervention or oversight over this is something which is perhaps missing, and it's telling also in terms of, if you look at rule 8, if I'm not mistaken, which essentially says to these platforms, I might be getting the number of the rule wrong, but complying with the entire gamut of things, right? You do the classification, you implement, you follow the codes of conduct, you do everything that is expected of you by the law. Yet you are not an intermediary, so therefore there is no safe harbor for you, and you still continue to be governed by the laws of the land and can be subject to, you know, cases filed against you all across the country. So what really is the benefit of this grievance redressal mechanism for the industry at large is not something which comes out very clearly from these rules at this point. I'll leave it at that.
Sure, thank you. Prashant?
Yes. Okay. As far as the grievance redressal mechanism for intermediaries and significant social media intermediaries are concerned, I think there are a lot of positives there and also some caution to be exercised. One, it's definitely a good thing that we have now a provision for something similar to a putback provision, where you can appeal what's been done. Let's say if there is a takedown, and then you can ask the intermediary that the intermediary is to inform the user why the decision was taken, the process by which the decision was taken, the reasoning for that. And then you get an opportunity to tell the intermediary that this is wrong. I feel that my content was wrongly taken down. And you can ask for putting it back. So that, I think, definitely is a good provision. And also there are a lot of clauses which could lead to a better transparency of the entire procedure when the content is taken down. And sometimes, again, the timelines could be a problem when you talk about 24 hours, 36 hours. I mean, the intermediaries and the industry will be better placed to comment on this, but then such strict timelines can be a problem sometimes, especially if they are like smaller intermediaries. That said, in many cases, you find that when there are even genuine complaints raised before the intermediaries, grievances raised, users don't even hear back from the intermediaries the common grievance. So when you have a specific provision added which will address that, I think that is definitely a positive. But one caution here: this shouldn't lead to, let's say, diluting of what was held in the Shreya Singhal case, where, as far as the intermediaries are concerned, their liabilities should be only when there is an order from a court or from a competent, let's say, or appropriate government authority. And again, there could be issues with who this appropriate government authority is. That needs more clarification.
Thanks.
Sure.
Rahul, I'd like to bring in Robin and Anand to discuss more on what they wanted to talk on, especially tracing the originator, in India, or the first originator, if they have any other points they want to make, and then perhaps Kazim.
Thanks, Ramita. Shall I briefly go first?
Yes, Robin.
Yeah, well, this was the first time I'd heard someone explicitly say that this is not based on the assumption of access to the encrypted data. So the implications of that, to my mind, are that someone receives a piece of objectionable data and they report it somehow. So that, to me, immediately raises some practical questions. We know, for example, that in the case of child sexual abuse material, these networks of abusers can be extremely security conscious, obviously, and very closed and very paranoid. And so it seems to me that this provision is relying on someone inside that network reporting their own illegal content. And that seems to me to be very optimistic. So I'm not quite sure how that's going to work. Two alternatives that we've seen elsewhere are, in terms of law enforcement for that kind of closed criminal network, are first, that you do normal police work and you infiltrate the network. So you've got someone who is considered to be a member of that group, but is actually an informant. Under those circumstances, you don't need any measures that weaken the security because you've got someone on the inside. So these measures are then more or less pointless. The second option is this idea called client-side scanning. And the idea there is that if you accept that when it's in the encrypted tunnel, you can't see the content, then the only way you can tell if it's objectionable or not is to scan it either before it's encrypted and put into the tunnel or after it's received and decrypted. And I'm concerned if these proposals lead to technology being used for client-side scanning, because the implication there is that you compromise someone's device. Now, if that's done in a targeted way, and you actually hack one individual's device because you know that they're in a network like that already, then maybe there's an argument for it on necessity and proportionality grounds. But if what you're calling for is a general switch on every device of a certain type, that means that you can flick the switch and say, okay, I want to pre-scan the content on that app, on that kind of device, even if that's invoked for a specific individual. I think that is a systemic weakness, which is of great concern. The general ability to flick a switch and say, if it's a device of that kind running that app, I want to be able to pre-scan the content. That I think is a fundamental flaw that we should be very worried about.
Thanks, Robin. Anand, do you want to make your intervention?
Yeah, so broadly, if I understood the proposal, I mean, this is what worries me. It is based on a fundamental misunderstanding about the technology itself. And so they're still stuck in the era of using digital signatures and hash values and so on. But none of this is actually being used at all on end-to-end encryption. So even if theoretically you can come and say you have to comply, I mean, how would the intermediaries comply? They just basically have to rebuild their own system and go back to 1970s. I mean, basically, I would call this as a glorified half-baked email system about digital signatures. And so the claim that none of this is going to change E2E is not going to stand ground at all. And so the other interesting thing that we normally do in these cases when people come and say these claims that it is doable, that is not doable, is that you publish a cryptographic proof, you publish a paper, you say how it is being done, you tell and ask people for feedback and so on and so on. And then you can even go law. And this is like writing a law which says, you know, my pipe should not leak. I mean, it's going to leak. Right? I mean, how will anyone go to do about it? So there is a very, I mean, and this is something that I've never seen before. In every jurisdiction where we have had this kind of issues, people would come and ask for exceptional access. I mean, give me a backdoor. Or, I mean, and in the case of the US, you think it would be most around, should I get device access? The most famous being the sandbagging is about a particular device. The idea that you can embed an information inside a message and which will somehow magically track it is something pretty out of the world kind of thinking, which is pretty much negated by cryptography. I mean, that's basically how I would see it. Really. The other interesting thing that I found about this is, the message originator, if it isn't from India, which is kind of weird because I use a $1 service in the US, which gives me a whole bunch of geographic numbered locations, Twilio, Sinch, Pars, and I keep changing my numbers. Sometimes it's +1 US, sometimes it's +61 the EU, sometimes Belgium, New Zealand. I keep changing it every 15 to, I mean, it's now, earlier it was 15 months, it's probably about 3 weeks, 4 weeks. And so what exactly are they trying to do here, right? You should only enable it if the number originator is from +91. I mean, I'm not going to send any +91. And then the other interesting thing that's going to happen is, if this is the trick that I write about it, everyone is going to switch to $1 Twilio accounts in India because, like it or not, a SIM card, a prepaid SIM card in India is about 95 to 100 rupees a month. and a Twilio number is $1, which is about 75 rupees. It's easier for you to get a cheaper number from abroad than what you get from a SIM card in India. So fundamentally, now you see the entire country is outside the jurisdiction. What are you going to do about it? And so this is not really well thought out. And I'm not very sure there is any technical consultation about how they're going to do about the whole thing at all. I mean, that's basically my viewpoint.
All right, Anand, I think that's very valid, and that is why we wanted to raise these concerns, because the government thinking on these issues is from the viewpoint on how it can ease out the governance mechanisms which can help issues of public order, safety concerns, etc. But how technology is rolling out and whether these mechanisms are even possible and what it requires for the organizations to do, that is something that remains the crux and focus. And through this discussion, and hopefully we'll have more focusing on this aspect, we will be able to pass on the message or bring to convergence on the issues of how do we sort of deal about the elephant in the room, how we want to address it. So what I'm going to do next is
we officially have 10 minutes, but
yes.
We need to get the speakers, and I think you want to get a special person in now.
Yes, so I'll invite Kazim, but before I do that, I'll invite Rohit Bhattacharya, who was the winner of the debate competition that the Dialogue organized. And since we wanted young students, because they are the future, these rules will impact them more than us. So we wanted to get their views and their insights on what do they think about these rules. So Rohit, are you able to hear us?
Yes, I can hear you. Just checking if I'm audible.
Yes, you are. Please go ahead.
Yeah. I think all the technical experts here have made very valid points regarding the technical aspects of the law. As a law student myself, I just wanted to make one point regarding the legality and constitutionality of these new rules. And my point is with regard to delegated legislation. So these rules are an example of delegated legislation as they have been drafted by the INB Ministry under the power that the IT Act had given them to draft forthcoming rules to govern information technology matters in general. But it might be postulated that when the IT Act was from our past in 2000, at that time, the regulation of OTT platforms or digital news media or several other things which are included in these rules was not envisaged by Parliament to be done through delegated legislation at that time or within the IT Act also. Which is why I think maybe to some extent, maybe this in some cases might be an example of excessive delegated legislation, even though it may be well-intentioned for the purpose of regulation. And such rules not being passed through Parliament, not going through scrutiny of standing committees and joint parliamentary committees in Parliament, and then ultimately, if they have lacunas, them just being left for the judiciary to then check or for such discussions to clarify, then becomes a little problematic. So that's the point I wanted to raise. Thank you very much for allowing me to speak, and I also benefited from hearing the views of many experts here. So thank you.
All right, thank you, Rohit. And then Kazim, over to you.
Thanks, Rahul. Thanks a lot. Thanks, Amrita, for calling me back in. I have two major points to sort of make in my limited time. One is on the whole issue around proactive monitoring of content. And I have the rules in front of me. If you look at Rule 4.4, basically what it talks about is the fact that a significant social media intermediary shall endeavor to deploy technology-based measures, not just for any child sexual abuse or CSAM content, but also for any content which is identical in relation to information that has been previously removed under clause 3.1d. Now, if you read 3.1d, what it really talks about is any content which prohibited under the law for the time being enforced in relation to the interests of sovereignty, integrity of India, security of the state, friendly relations with foreign states, etc., public order, decency, morality. So the point is that the ambit of 4.4 for proactive monitoring of content is quite wide. It's beyond the CSAM, child sexual abuse material. It's very wide. It's worded in a way which is why I think there should be some consultation on narrowing down this provision particularly. However, of course, it talks about that the intermediaries shall endeavor to do it. So there is a gray line there. But the point is that we know that once this comes in, this could lead to censorship, that intermediaries could end up overcompensating, and that could lead to censorship of content. So I think you have to be a little wary of this. And I really welcome maybe some consultations, some discussions on narrowing down this particular provision. So that's the first submission I wanted to make. And the second submission is, of course, around, we've been listening to Anand and Mr. Azad has spoken, and I think Robin has also sort of pointed out around traceability. A couple of areas which I sort of wanted to bring about was one on the impersonation of the users. If you start having digital identities to everybody, what will end up creating are bigger problems than the solutions will end up solving, right? We've seen that with Al Qaeda. I think they have been able to create, they have the technology to create encryption tools. We don't want to sort of put the infrastructure in such a challenging position that any bad actor or a non-state agencies finds a way to hack into it, number one. Number two, if they start moving out and creating their own encryption tools, then that will sort of really hamper the effort of the law enforcement agencies. So I think you have to be a little wary of that. And I think a lot has been spoken around the security issues of breaking encryption. My last submission is around checks and balances. I do feel that we should have waited for a personal data protection law to come in before we pass this provision, because right now the user privacy will be compromised if the rules are not implemented in the right spirit. We hope and we expect them to be, but at the same time, as lawyers and as policy professionals, it's always important to narrow down. So the overbroad language of the rules throughout is something which I think the government must look into. I think it's important to balance the security of the state and have targeted surveillance measures rather than overbroad surveillance measures, because I think that will not only hamper the effectiveness of the surveillance sort of implementation authorities, but it might also end up creating more problems. I mean, if let's say a bad actor who has access to technology can impersonificate a user and replace the originator from the original originator to somebody else, then we could end up sort of running behind the curve, and we could end up sort of very helter-skelter, sort of scrambled with problems. So I think we have to be a little wary of that aspect. So these are my sort of main submissions.
Thanks, Kazim. Rahul, we have 3 minutes, but we need to give our two speakers some time. So perhaps extending by 10 minutes more, if it's okay with everyone.
Yeah, sure. So like what we'll do is, we'll invite Napina, but just before we invite her, like, very important points raised by, Kazim in his intervention on, the aspect of, the government bringing out these rules, and, which gives us feeling that, they are trying to have, cast a wider net and trying to identify things which are going to be problematic. But, having specific provisions and features which allow government to make very targeted interventions and not broad-based interventions, I think that is what is required, and hope that as rules evolve, we'll move in that direction. And specifically, because Kazim, you also did earlier also this point, right, we did not discuss in detail on the compliance challenges. Prashant also raised it briefly on because intermediaries, as a large scale, small, large, everyone has to do certain requirements for compliance, for maintaining compliance against these rules. So what are the compliance challenges? Unfortunately, we do not have many speakers from industry who are willing to join and speak on these matters. Probably like they're trying to understand these rules much better, and hopefully going forward we'll have like more industry voices who can talk about these issues. But also I wanted to raise about one point. Robin wrote in this that, and cousin, this relates to your comment. Having it's not healthy in a democracy for people to be forbidden to go online unless they authenticate themselves. I specifically remember that in this debate happening in a government circle, whether they ask the intermediaries to mandatorily allow user authentication, so that every user which comes online and publishes content has to be authenticated by, or some KYC mechanism, some mechanism to identify the user. In the personal data protection bill, this aspect also was mentioned, although it doesn't concern, but that it could be voluntary mechanisms, and in these rules also, the government made this as a voluntary mechanisms, not mandating users to not mandating intermediaries to ensure that all the users are required to be KYC'd or authenticated. Over to you, Napinai ma'am. We wanted to have your last words, remarks, and any areas that
and then Arun.
Yeah, and then Arun. Yes.
It's already been a very long day. I won't take too much time. Okay? Very interesting conversations and interesting points. Two things I thought I'll just focus on and close out today. One is the last thing which you mentioned about this voluntary identification process. So on this aspect, as I just posted to Robin, on his client-facing surveillance possibility, I would like to, my concern is this. Already, see, we are always talking about the big brother, government as the bad egg here. And we tend to forget the kind of problems we are facing from the platforms. It's important for us to have a focus as users on every possible problems we are likely to face, right? So this is my response to you on this, voluntary or mandatory, okay? What is the issue? Because we are constantly talking about, is automated tool going to stop the bad actor? Is this going to stop the bad actor? Will it cause more harm to the common user rather than the bad actor, etc.? So look at the kind of harm it can cause to users from platforms. We are already being subjected to corporate surveillance at a very high level, okay? But basic safety measures which we would normally mandate, and we've all been doing it from early days in terms of social media or even starting an email account, etc., is as much as possible we'll try not to share personal details there, right? Because then you're exposing yourself that much more. And when you say about personal details, that includes you sharing your actual birth date, etc. Now, today, when you give a voluntary or a mandatory process an ID, you are giving so many more data fields to a corporate entity than they are entitled to otherwise, nor did they have the possibility of accessing the same till now. Because every single identity document is going to carry such a huge number of data. And when you talk about whether it's really going to limit the harm, I'm only going to rely on all the trends of cyber crimes we've been seeing now. Every single financial crime relies on a banking channel. Every bank is supposedly doing a very detailed KYC norm. And every know your customer norm mandates the submission of multiple identity documents. And yet, fake bank accounts are being opened, monies are being siphoned out using these fake accounts. Nobody has taken the responsibility in terms of these fake accounts, and the victim suffers, right? So two things were pointed out. One is what happens to the victim whose identity documents will be misused by the criminal. And two, how sacrosanct or genuine or efficacious is this process of verification. So from a government surveillance or a corporate surveillance angle, I personally feel this is an extremely injudicious measure, which is not really taking into account practicalities, and therefore that needs to be really relooked. That's one point I wanted to make. And one clarification. The 31.31D, which Kazim pointed out, refers to the takedowns based on a government order or a court order. Therefore, that's the check and balance that's being built into it. And if you look at what is supposed to be done based on 31D, it is only a warning message that this is content which has already been identified to be ABC. And therefore, I don't see that as being of that larger concern. As I had already flagged earlier, the issue was about whether these kind of automated tools will then be expanded to other kinds of speech restrictions, What I see now is there was a lot of resistance to use of these kind of tools for rooting out child sexual abuse and rape and gang rape videos. But we are already seeing these kind of automated tools being deployed for hate speech or fake news. Every single platform is already doing it. So the issue is really not about whether this is going to cause that harm. It is more about ensuring or protecting against harms which are already there, but deploying it for the right reasons. We can't throw the baby out with the bathwater because of the hypothetical fear. We need to look at the real fear situation, which is already there, and we have enough illustrations of it. So thank you all again for this.
Thank you so much, Napini. It was, you really made some very pertinent points. Arun, over to you.
Thank you. So I'll just drop a link to the reading list that we have created on OTT content regulation, streaming regulation, in particular, curated platforms like Netflix. I think this focus area is going to be very, it's going to assume a lot more importance as these platforms and the content they make assume a central position in the national discourse, just as films and other media have over time. The Central Board of Film Certification has actually been a remarkably transparent body in the sense that you can get a list of cuts of every film that goes through the institution. Filmmakers can get notes of, why a movie was rejected, what individual filmmakers had to say. I mean, the entire process is problematic, but and it's kind of a idiosyncrasy in a democracy. But there is a case to be made that if this process is going to happen, if today we had a development where all the streaming services apparently consented to the regulations and said, okay, we will comply, we welcome this. So the bare minimum expectation that I think we should have is that both the self-regulating body as well as the government exercise as much transparency as is appropriate and needed, because there is nothing, unlike in the case of social media, there is no personal data involved most of the time. And these are cases where each complaint is of public interest. And really, every instance of a complaint actually being taken to a stage where censorship can happen needs to be examined thoroughly and reported on very intensively. And I hope that happens. Thank you.
Thank you so much, Arun. And, thank you so much, everyone, for being there. While this discussion is, this rule has a wide-ranging effect on various aspects, but we couldn't cover everything today. We just tried to look at it from the high level. We really thank you for patiently being here with us for more than 2 hours. We hope to have, as Rahul mentioned, more conversation, perhaps starting with traceability. Any comments, feedbacks, you can, reach out to us. We've shared the link where you can look at the today's session. But Rahul, I'll pass it on to you in case you have any points. And of course, from CCAOI, Internet Society Delhi, and the Perspective, we're really thankful for all of you being here, the panelists, the audience, and even Mr. Maheshwari, who patiently answered and responded to questions. Rahul, over to you if you have anything more to add.
Sure. The last parting comments, Amrita. I think thank you everyone for joining in. Really great to have experts from various backgrounds sharing their views on different provisions of the rules. As you said, like, these are wide-ranging rules which have impact on all of us in some form through the different services we access, and it's really useful to get views of different stakeholders and get government in the room to try and listen to the conversation, to like what people are talking and thinking about. So I think from that viewpoint, we'll have more such conversations. We also invited Mr. Vikram Sahai, and till 6:15, like, he was supposed to join, but due to some urgent meeting, he's a joint secretary of MIB, but he could not join. But we'll hope that we can have him for future discussions, specifically on the topic of publishers, regulating publishers, and the self-regulatory and oversight mechanisms for the digital media. I think that's going to be a big issue as we move forward. All the pertinent points raised by different speakers and let's hope that we carry on these conversations. Really interesting to hear different viewpoints. Specifically, like we discussed technical aspects, we discussed policy aspects on the legality of rules, on what self-regulatory mechanisms can be, and the compliance challenges. So like the discussions have been very varied, and I hope that we can continue to focus on deeper aspects as we move forward. Thank you everyone for joining in. Thank you everyone, the speakers and panelists, for sharing your views.